Most business owners think they are protected because they've registered their business name, they have the LLC, they have the paperwork, they put the name on their website and their contracts. They also may have their social profiles. And most of all, they assume that means their name is theirs. It is not. And today I am going to show you exactly why and what you need to do instead. Hey there, if you don't know who I am Tenicia Moulden. I am an IP attorney and brand strategist. I work through AI and automations and IP and integrate all of those to help service-based entrepreneurs build the business of their dreams. Before I get into it, I want to make sure we are clear on terms because this is where the confusion could start. There are two things people mix up constantly: a trade name and a trademark. They sound similar, they are completely different. A trade name is the name your business operates under. Your LLC name, your DBA, the name you filed with the state when you started your business. It lives at the state level. It tells the government and the public what your business is called. That is it. A trademark is something entirely different. A trademark is a federally claim of ownership over a name, word, logo, or a phrase, as it is used in the marketplace to identify your specific goods or services. A trade name says, this is what my business is called. A trademark says, this name is mine and I can prove it and enforce it. Think of it this way: your LLC name on a state filing and Nike on a sneaker are doing two completely different jobs. Now, here is where it gets important, and this is the part most people never hear because they are not sitting across from an IP attorney, but you are right now. The USPTO, the United States Patent and Trademark Office, does not care that your name is registered with your state at all. What the USPTO cares about is one thing: use in commerce. Are you using this name to identify the source of your services to the public? Is it functioning as a brand identifier, not just as a label on a business filing? Because here's the thing: the moment your name appears on your website next to a description of your services, the moment a client sees your name and connects it to what you do, you have crossed into trademark territory. You are already there. You just have not claimed it. Really think about your own business right now. Your name is probably already functioning as a trademark, and you do not even know it. And when you are operating in trademark territory without a federal registration, you do have something. It's called common law right. You've built those through use. They are real, but they are limited to the geographic area where you operate. They are hard to enforce, and they do not stop someone in another state or someone watching your market from filing a federal trademark on that same name before you do. Once they file and you have not, they own it nationally. You may not even be able to keep using the name you built your business on. So let's talk about how you actually move from trade name territory into trademark territory, because this is where most people get tripped up, even the ones who try to do it themselves. When you file a trademark application with the USPTO based on current use, you have to submit what is called a specimen. A specimen is not your logo. It is not your LLC paperwork. It is not a business card. A specimen is a real world evidence that your name is already functioning as a trademark in commerce. It has to show your name being used in direct connection with the services you offer in a way that a real customer would actually encounter it. For example, for service-based businesses, here is what works. A service page on your website, not just your home page with your name at the top. A page where the name appears alongside a clear description of what you do or what you offer. That connection matters. Here's another one. A signed client agreement or proposal with your name in the header and the services described in the body. And even better, an active booking page or intake form where your name is visible in context with your service offering. Maybe even an email marketing or a newsletter header where your name appears alongside your service categories. Uh, I do see people submit logos on a white background, a blank letterhead, maybe through social media profile photos. The USPTO will reject all of those because they do not show the name connected to a service being offered in commerce. The specimen has to tell a story to the examiner that can follow the name, the service, the business in use right now. Getting the specimen wrong is one of the most common reasons trademark applications get refused, not because the name is not protectable, but because the proof submitted does not meet the standard. Which brings me to the part I really want you to hear. The filing itself is accessible. Anyone can go to the USPTO website and start an application. The strategy behind it is not something you want to figure out as you go. Choosing the right filing basis, selecting the correct international class for your services, and yes, there are 45 of them. Identifying a specimen that will hold up to examination, running a clearance search before you file so you are not building equity in a name someone else already owns. Hey, these are not administrative steps. They are legal decisions. And getting them wrong does not just cost you the filing fee, it can cost you the name. So imagine your founder who's built 4 years of equity, had the LLC, assumed it was covered, and then find out that someone else had filed. This happens every day. You can use your common law rights to fight it, but it could cost you months and fees that a single conversation before filing would have prevented. A professional does not just file your trademark. They make sure what you file actually protects what you've built. So here's where I want to leave you. If you are operating publicly under a name right now, you are already accumulating rights worth protecting. The question is whether you have the right person helping you formalize them. The next step is not a Google search. I have put together the Brand Digital Guide, 5 zero-cost actions you can take right now to audit your brand protection before a gap costs you more than it needs to. The link is in the description, and if you are ready to sit down with an IP attorney and get a real picture of where your brand stands, gaps ranked by risk, a written action plan, 60 minutes, my brand ownership audit is the place to start. That link is also in the description. I would love to hear what your thoughts are on this video. If you have any question, go ahead and drop them in the comments. Please subscribe, and I will see you in the next one.